relevant writings provide no support for immunity of the type the petitioner claims. James Wilson, who was a justice of the Supreme Court, said, far from being above the laws, the president is amenable to them in his private character as a citizen and in his public character by impeachment. Wilson, so then here we go. James Iredell, another justice of the Supreme Court, said if the president commits any crime, he's punishable by the laws of this country. Alexander Hamilton likewise confirmed that a president, unlike a king, would be liable to prosecution and punishment in the ordinary course of law. That's Federalist number 65. So that's a historical document. So here, Jack Smith is going through historical documents to point out how Donald Trump's immunity claim is not supported by how our jurisprudence has developed for the past 2.5 centuries. Then we have the events of Watergate similarly reflect a broad understanding that former president may be prosecuted for official acts. During Watergate, President Nixon was the unindicted co-conspirator. President Nixon resigned after release of the tape revealing his misuse of the CIA, yet no one suggested that he was immune from federal prosecution once no longer in office. To the contrary, Ford's pardon of former President Nixon and his acceptance rested on the understanding that the former president faced potential criminal liability. Both men were aware of and relied on this Constitution statement in Verdict v. United States, that acceptance of a pardon represents a commission of guilt. During the Watergate era, DOJ rejected as unreasonable the claim that an offending federal officer acquires a lifetime immunity against indictment unless Congress takes time to impeach him. And former President Nixon, despite his capacious view of presidential privileges, acknowledged a president may be indicted after he leaves office at the end of his term or after being convicted by the Senate in an impeachment proceeding. Subsequent investigations by independent and special counsels have taken as a given that a former president can be prosecuted for official acts. Independent counsel investigating the Iran-Contra case found that there was nothing that President Reagan did that would warrant criminal prosecution. But no president before or since suggested the prospect of criminal exposure had a chilling effect. And not until petitioner's brief in this case has a former president suggested that the Constitution affords him criminal immunity.